So what happens when there are two different wills? One is preferring a singular child over the others, and the prior is split evenly among them. Well, I'm going to give you the answer in just a minute. Before I do, if I'd like you to think about a close friend of yours who's going through a challenging what-if scenario that creeps into their lives, but they were prepared because you shared this video. We would appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to educate everyone for free. So please drop your questions for us, and hopefully together we can help some folks along the way. Now, when there are varying wills or last wills and testament, typically, and this applies really to trusts as well, the more recent will be seen as the controlling estate plan, because they typically will say all priors should be ignored. That's not to say that other evidence couldn't be brought in to show that the current plan should be disregarded. Now, I would say with a last will and testament, the two primary reasons why a current will may be disregarded, in which you would have to show, is first, that person who created it, maybe your parent, was put under duress by somebody else, such as maybe the sibling who ends up receiving a lot more in the newer one. Or that person didn't have the capacity to sign and execute that last will and testament. Now, the threshold for signing a last will and testament is not super high. The individual just has to be aware of what their assets are and to whom they would like them to go. But there are many different factors that go into determining, and this is typically through, an estate litigation type matter, which our office does not handle, by the way. But there are various factors that you would have to look into to determine whether or not that new will, the newest will, was valid. Right? What was the age of the person when they signed it? What was their health, right? Are there any signs of dementia or Alzheimer's? And how long was that person ailing from those things? What's the relationship to the other parties? Are there multiple wills from the past that show the same thing up until that last one, right? And was there an outside explanation of the changes, whether it's in the document or in a letter written by the decedent themselves? I would say if you feel that there was some sort of duress or that your parent was not in their right mind when they signed the newest estate plan, you should seek counsel from an estate litigation attorney and present your case within the court. Again, our firm does not handle those types of actions, but it does happen on occasion, and you want to make sure you have representation to help secure probably what could have been the true intent of your parent. We hope that you've learned something here today and that you choose to share. And as always, please take care.